Welcome to this Babies Can't Wait online presentation focused on procedural safeguards. These safeguards have been established by the Georgia Department of Public Health Babies Can't Wait program to protect the rights of infants and toddlers eligible for Part C services and their families throughout the early intervention process. We will break the Federal Procedural Safeguards policy and the related state standards into 3 sections for the purposes of these trainings. These trainings are confidentiality and records, parental consent and surrogate parents, and dispute resolution. The focus of this presentation will be on dispute resolution. Hello, I'm Jade Costin, a member of the Babies Can't Wait Technical Assistance Unit through my faculty work at Valdosta State University. At VSU, I serve as a faculty member in the Department of Communication Sciences and Disorders. As an SLP, I, along with the other members of Georgia's Babies Can't Wait Technical Assistance Unit, have focused my career on developing expertise in early intervention, including the requirements of Part C of the Individuals with Disabilities Education Act, or IDEA. As the statute and its associated regulations change, and as our knowledge base of effective, evidence-based practices grows, Georgia's Babies Can't Wait program standards are continuously reviewed and revised as appropriate. Please allow me to serve as your guide today as we take a brief overview of the highlights of Georgia's revised standards. In the next few minutes, you will learn more about the updated standards for Georgia's procedural safeguards for infants and toddlers with disabilities and their families who are eligible for services under Part C of IDEA. Please take time to review the updated standards and become familiar with the content. This PowerPoint will only highlight a few areas, but the effective early intervention practitioner should be familiar with all aspects of the standards. The first section of the standards, formatted with bold text, contains excerpts from the actual federal policy. The second section of the standards, formatted with regular text, contains Georgia's standards for implementing early intervention. Bookmarks have been added to each section of the standards linked to this presentation to facilitate navigation. Once the file has opened, click on the bookmark icon located to the left of the text to open the Bookmarks pane. Procedural safeguards. The Individuals with Disabilities Education Act, or IDEA, is a federal law that governs how states and public agencies provide early intervention to children with disabilities and their families. The Georgia Department of Public Health serves as the state lead agency and is responsible for establishing and implementing procedural safeguards that meet the requirements of IDEA regulations. Just as a lighthouse is used to safely navigate or guide a person to shore, procedural safeguards serve to guide us through the early intervention system and are important protections for eligible children and their families, as well as for service providers. In this presentation, we will discuss the 3 mechanisms for the timely resolution of complaints: mediation, state complaint procedures, and due process hearing procedures. Definitions of terms. The BCW standards on procedural safeguards define or explain a number of terms used in Part C of IDEA. Let's review 2 of these terms to make sure that we are all using them in the same manner. The participation of a child's family is a very important part of Babies Can't Wait. Services and supports provided to a child and family when a child is very young are designed to support and facilitate a child's development. At times, families and service providers may have disagreements about the specific supports or services provided to a child. In those cases, a first step is to discuss these issues during the IFSP team meeting. If disagreements continue to exist, there are some other options that may be used to help resolve these disagreements. 2 of these options are mediation and due process hearing. Within the standards, mediation is described as a voluntary process that may be used to facilitate the resolution of a complaint in an informal, non-adversarial atmosphere. A due process hearing is defined as a formal procedure conducted by an impartial hearing officer to resolve a complaint or disagreement. In this presentation, we will discuss additional information about both of these topics. Dispute resolution. Throughout the early intervention process, many decisions are made regarding the services and supports to be provided to an infant and toddler and his or her family. Occasionally, a situation may arise in which the family disagrees with the Babies Can't Wait program. It doesn't happen very often, but when it does, families are protected by many rights. As a first step in resolving disagreements or conflicts, BCW providers and the child's family should engage in informal discussions to see if they can reach a consensus. There are several possible courses of action from which families may choose. Families may consider contacting their service coordinator and discussing the concern or problem. It is possible that it is a misunderstanding that can be easily corrected by the parent and service coordinator working together. If the issue cannot be resolved with the service coordinator, families may consider contacting the Early Intervention Coordinator, or EIC, for the district in which they receive services. He or she could be very helpful in determining the cause of the disagreement and helping to resolve it. If the issue cannot be resolved at the local level by working with the service coordinator and early intervention coordinator, there are 3 mechanisms in place for which written procedures are available. These mechanisms include mediation, state complaint procedures, and due process hearing procedures. Each of these mechanisms will be described in detail. Purpose. As described in the term slide, the purpose of mediation is to facilitate the resolution of a complaint or disagreement in an informal, non-adversarial atmosphere. Families cannot be required to use the mediation process. It is voluntary for both the family and the BCW program personnel, and it may be used at any time during the early intervention process, including after a parent has filed a request for a due process hearing. Both the family and the BCW program personnel must agree to use the mediation process, and if both agree to mediate the complaint, the mediation must be provided at no cost to the family. Mediation must not be used to deny or delay any of a parent's rights under Part C of IDEA. Even if a family and BCW program personnel agree to mediation after a due process request has been filed, the timelines regarding due process hearings that will be discussed later in this presentation remain in place. Mediation may address individual child issues or issues involving service delivery to many young children with disabilities and their families. Mediators. Mediation includes the use of a mediator who works with both groups who have expressed a disagreement. The lead agency in Georgia, the BCW program, is responsible for selecting a qualified individual to provide mediation services. Mediators must be impartial, trained, and knowledgeable. An impartial mediator is one who does not have any conflicts of interest that may bias his or her viewpoint and understanding of the situation. Mediators must have been trained in effective mediation techniques and must be knowledgeable regarding early intervention laws and regulations. The Georgia BCW Program Office maintains a list of qualified mediators and impartially selects mediators. The method of selection of a mediator for an individual situation may be random, rotational, or by using another impartial basis. Mediation may occur with a complaint related to an individual child and/or family. Both parties, usually the family and BCW personnel, must agree to use mediation in an attempt to address and resolve the complaint. The request for mediation must be in writing and must be presented to the local BCW office. Included in the written, signed request must be a statement identifying the points of disagreement. The disagreement may relate to the identification, evaluation, or placement of, or provision of, early intervention services to an infant or toddler with a disability. The child's parents may simultaneously file a request for mediation and for an impartial due process hearing. If a mediation results in resolution of the disagreement before the impartial due process hearing is conducted, that hearing is canceled. The decision to request mediation is a joint decision made by both parties and cannot be used to delay an impartial due process hearing request and provision of a timely hearing and resolution within 30 calendar days of the initial request. BCW personnel and early intervention service providers should encourage families to file for mediation as one approach to conflict resolution. Process. Mediation may be conducted in a variety of locations. The mediator will review the specific details of a complaint and information about the mediation process with both parties, usually a family and the BCW personnel. During this conversation, convenient times and locations will be discussed, and the mediator will schedule the meeting at a time and location that will be convenient to both parties. Either party may have an attorney present at the mediation meeting. The mediator must be notified at least 48 hours prior to the scheduled mediation meeting. The goal of mediation is to resolve the dispute or disagreement. If this goal is met and the dispute is resolved, both parties, again usually a family and BCW personnel, must sign a legally binding written agreement that is enforceable in any state court of competent jurisdiction or in a district court of the United States. There are some specific requirements of written agreements. We will discuss those requirements next. Written agreement. The mediation agreement must not conflict with state or federal law or policy of Georgia's BCW program. The written agreement that is signed by both parties must be to the satisfaction of both parties, and their signatures indicate that satisfaction. Both parties are given a signed copy of the agreement at the end of the mediation session. If a written agreement occurs, the Child Service Coordinator is responsible to convene the IFSP team so that any necessary changes in the IFSP may be made. This meeting must occur within 5 working days of the date the agreement is signed. State complaints. A second option for resolving conflicts identified in IDEA is the use of a state complaint procedure. BCW program standards provide information for providers and families regarding the Georgia state complaint process and procedures. Content in the standards includes information regarding the state's adoption of complaint procedures, remedies for the denial of appropriate services for an infant or toddler with a disability, the minimum complaint procedures for the BCW program, and the procedures for filing of complaints. Each of these topics will be addressed in this section of the PowerPoint presentation. Procedures. The requirements for Georgia complaint procedures are described in greater detail in the standards. Complaints may be written, signed, and submitted by public agency personnel, by private individuals including family members, or by representatives of an organization. Complaints must be filed with the Georgia BCW office no later than 1 year after an alleged violation of Part C of IDEA has occurred. The complaint may allege violations of Part C of IDEA by any public agency in Georgia that received Part C funds, including the Department of Public Health Georgia BCW office and the State Interagency Coordinating Council, other public agencies involved with Georgia's BCW program, or public or private service providers receiving Part C funds. The individual or organization representative filing the complaint with the BCW state office must provide a copy to the public agency or early intervention service provider against whom the complaint is filed at the same time as the complaint is filed with the state office. Awareness. Each local BCW office must provide information regarding complaint procedures to parents of infants or toddlers involved in the BCW program. This information should be provided through service coordinators and parent educators. Other interested parties are informed about complaint procedures through the local Interagency Coordinating Councils, or ICC, and other local public awareness efforts. Written complaint. Each written complaint must include the signature of and contact information for the individual filing the complaint. A statement that a requirement of Part C has been violated for an individual child or group of children, as well as the facts that form the foundation for the complaint, are components that must be included. If the alleged violation or violations relate to a specific child, the complaint must include the name and address of the child, name of the early intervention service provider serving the child, a description of the nature of the problem, and a proposed resolution of the complaint. Remedies. If following the receipt of a complaint, it is determined that a child has not received appropriate services, the lead agency must address its failure to provide appropriate services to the infant or toddler with the disability and his or her family. Corrective action plan or plans that are appropriate to address the needs of the infant or toddler with a disability and his or her family must be developed. These plans may include strategies such as compensatory services or monetary reimbursement. Additionally, the plan must address appropriate future provision of services for all infants and toddlers with disabilities and their families. After a complaint is filed, state complaint procedures provide specific guidance regarding steps that are taken after a complaint has been filed. In general, once a complaint has been filed, prior to rendering a decision, each lead agency must complete an independent on-site investigation within 60 days if determined necessary. Information is gathered from both the individual or representative of the agency filing the complaint and from the lead agency personnel, public agency personnel, and/or early intervention service provider named in the complaint. Following this information, the lead agency makes an independent determination regarding whether or not a violation of a requirement of Part C of IDEA has occurred. Additional information regarding these specific steps will be highlighted in the next few slides. Obtaining additional information. Once a state complaint has been filed, an independent on-site investigation must be conducted if the BCW program determines that an investigation is necessary within 60 days. If an on-site investigation is determined necessary, an on-site team is established for this purpose. The on-site team is charged with taking necessary steps in order to make recommendations to resolve the differences or disagreements. This step may include a review of records, interviews, and on-site visits. Following the investigation, the on-site team makes written recommendations to the complaint officer. The individual filing the complaint is provided with an opportunity to submit additional information about the allegations in the written complaint. This information may be submitted orally or in writing. Additionally, representatives of the lead agency, public agency, or from the early intervention service provider against whom the complaint has been filed are also given an opportunity to respond to the complaint. Obtaining additional information continued. The lead agency, public agency, or early intervention service provider responds to any complaint filed. The complaint officer sends, in writing, information about the issue and requests a response within 10 working days from the local lead agency and/or BCW service provider directly involved. The local lead agency and/or BCW service provider involved is required to respond directly to the complaint, stating in writing any explanations or actions to be taken. After additional information is obtained, after reviewing information gathered from both parties, a proposal to resolve the conflict may be made at the discretion of the lead agency, or the lead agency reviews the information and determines whether or not requirement of Part C of IDEA has been violated. A parent who filed a complaint and the lead agency, public agency, or early intervention service provider against whom a complaint was filed may voluntarily engage in mediation. Written decision. If the complaint is not resolved through mediation or other avenues, the lead agency will review all information and independently determine if a violation of a Part C requirement of IDEA has occurred. Following this determination, the complaint officer must send, in writing, the steps necessary to resolve the complaint. The lead agency issues a written decision to the complaint. This decision must address each allegation in the complaint and includes findings of facts and conclusions as well as the reasons for the lead agency's final decision. Included in this letter of notification are specific requirements and timelines that must be met in order for the agency or provider to continue to receive IDEA Part C federal funds. Copies of the final letter outlining the procedures are sent to all appropriate parties to the complaint. The timeline for the written decision is 60 days. Extensions of the 60-day timeline for responding to the complaint may be granted if the complainant, lead agency, public agency, or EIS provider agree to engage in mediation or due to exceptional circumstances that exist with respect to a particular complaint. BCW state staff may provide technical assistance to local lead agencies and/or BCW service providers or may use other means to assist with compliance. Filing a complaint. Written complaints from any public agency, private individual, or organization or representative regarding the provision of early intervention services for an infant or toddler with disabilities or a group of infants or toddlers with disabilities should be addressed to Babies Can't Wait, Georgia Department of Public Health, Number 2 Peachtree Street Northwest, Room 11-216, Atlanta, Georgia 30303-3186. Review of contents of a complaint. In review, for a state complaint, the written complaint must include the signature and contact information for the complainant, and a statement that the lead agency, public agency, or EIS provider have violated a requirement of Part C of the Act, the facts on which the complaint is based, If alleging violations with respect to a specific child, the name and address of the child, the name of the EIS provider serving the child, a description of the nature of the concerns related to the child and all relevant facts. A proposed resolution of the problem to the extent known and available to the party at the time the complaint is filed. The complaint must allege a violation that occurred not more than 1 year before the date that the complaint is received. The party filing the complaint must forward a copy of the complaint to the public agency or EIS provider serving the child at the same time the party files the complaint with the lead agency. Part C, Due Process Hearing. A formal procedure for resolving conflicts regarding Part C services is called a due process hearing. This hearing is conducted by an impartial hearing officer. The hearing officer must have specialized knowledge. This individual must know about the statutes, regulations, and rules that provided guidance and direction for the Babies Can't Wait Standards and Implementation Manual and the written procedural safeguards. Additionally, this person must have knowledge regarding the early intervention system, as well as the needs of and services available for infants and toddlers with disabilities, those eligible for the BCW program, and their families. The hearing officer must be impartial. This means that he or she is not an employee of BCW, is not an early intervention service provider for the child, and that he or she should not have any personal or professional conflicts of interest that may limit his or her ability to objectively hear and respond to the issues addressed in the due process hearing. In Georgia, the Office of State Administrative Hearings, or OSAH, provides administrative law judges who function as impartial hearing officers for due process hearings. Administrative law judges, impartial hearing officers. Several criteria exist for hearing officers appointed by OSAH to oversee BCW due process hearings. All hearing officers for these due process hearings must be active members in good standing with the State Bar of Georgia. And once appointed for a specific case, an administrative law judge must decline to hear the case if he or she has a conflict of interest. In the event that this occurs, the Office of State Administrative Hearings will assign another administrative law judge to hear that case. The due process hearing. The due process hearing is scheduled by the Office of State Administrative Hearings. The hearing will be scheduled at a time and location reasonably convenient to the family, and both the family and the BCW agency personnel will be notified of the time and location in writing. Information, including evidence to be presented, must be shared by both parties at least 5 calendar days prior to the hearing. While not required, it is common courtesy to advise all parties of the specific individuals who will be representing or accompanying each party involved. Parental rights. Families of infants and toddlers have many rights when they disagree with the identification of, evaluation of, placement of, or services provided to their child. A third method that may be used by families to resolve this disagreement is a due process hearing. The due process hearing procedures are available for disagreements regarding children eligible for BCW services and supports, and for disagreements regarding the identification and eligibility of children referred to BCW. Families initiate a request for a hearing by notifying the local BCW program in writing. The complaint must be signed by the parent or parents filing the complaint and must include specific content. Content to be addressed includes a statement identifying the point or points of disagreement related to the identification, evaluation, or placement of their child, or provision of early intervention services for their child with disabilities. Within 5 working days of receiving a written complaint, the local BCW program staff must ensure that the processes for resolving complaints are explained to the family. Additionally, the local BCW office staff must inform the family of the availability of any free or low-cost legal services and other relevant services available if the family requests this information or initiates a due process hearing under Part C. Parental rights continued. During the hearing proceedings, families have several rights available. They may bring others to the hearing. They may be represented by an attorney. If either the party or the agency will be represented by an attorney at the hearing, the Office of State Administrative Hearings and the other party must be notified within 3 working days after receiving the hearing notice. Additionally, families may present evidence and confront, cross-examine, and compel the attendance of witnesses. They may prohibit the introduction of any evidence at the hearing that has not been disclosed to them at least 5 calendar days before the hearing, as may the BCW personnel. And they must be provided at no cost to them with a written or electronic verbatim transcription of the hearing and a written copy of the findings of fact and decisions. Services to the child during the complaint period. During the complaint period or the time period between the filing of a due process hearing request and the hearing officer's decision, unless the BCW program staff and family agree otherwise, the child and his or her family will continue to receive the appropriate early intervention services in the setting identified in the IFSP and that are consented to by the child's parents. If the services for which the complaint was filed have not previously been included in an IFSP, the implementation of those services may be delayed until the complaint is resolved. If those services have been included in an IFSP prior to the complaint being filed, those services will continue to be provided until a resolution is reached. If the complaint addresses a child's initial eligibility for BCW services, no early intervention services are provided until the complaint is resolved. Due process hearing timelines. Once a request for a due process hearing is received by the Office of State Administrative Hearings, the hearing must be completed and a written decision must be issued to both parties within 30 calendar days. Either party may request a specific extension of time beyond the 30-day timeline. The hearing officer will determine whether or not this extension is granted. Civil action. Based on the findings and decisions of a due process complaint, the party determined to be aggrieved by the hearing officer may file a civil action. The civil action may be filed in a state or federal court and is filed under Section 639A(1) of the Individuals with Disabilities Education Act. Babies Can't Wait Technical Assistance. Thank you for allowing me to serve as your guide today as we completed a brief overview of the highlights of Georgia's revised standards for procedural safeguards with an emphasis on dispute resolution. A printable PDF version of the Procedural Safeguards section of the standards, as well as this presentation, have been provided for you on the References and Resources slide. If you have any questions after reviewing the standards, please contact the Early Intervention Coordinator for your district. References and Resources. Babies Can't Wait Program Standards provides a link to a printable version of the BCW standards for procedural safeguards. IDEA Part C Federal Regulations provides a direct link to the Federal Register as published by the United States government. These final regulations were issued on September 28, 2011 to reflect the changes made to IDEA as amended in 2004. PowerPoint handout links to a printable PDF version of this presentation. Public Law 108-446, Individuals with Disabilities Education Improvement, 2004, links to a copy of the actual act from 2004 reauthorizing the Individuals with Disabilities Education Act.